Okay, the Court of Appeals is now in session.
Good morning. Welcome to the Court of Appeals in a virtual session. We appreciate counsel joining us and indulging us for a few minutes in view of how long our earlier case ran on. We will hear argument in the case of Hinds versus Hinds-Holm. And the rules in our virtual session are pretty much the same as usual. 15 minutes aside for oral argument. Appellant can save some of that time for rebuttal and has apparently chosen to save 3 minutes for rebuttal. The couple of differences are that we will occasionally have technological glitches. For the most part, it's gone quite well. But we're very patient if somebody is suddenly having little circles on their screen. In the last case, my audio conked out for a minute. And my colleagues were kind enough to let me know about that so I could kind of start over to make my long rambling point. And so we'll all be patient with each other if that happens. We may have to remind one another that the mute button has been activated, etc. Secondly, it does improve the technology if when we're not talking, we all mute our microphone. And likewise, it helps if the attorney who is not actually arguing stops their video. Saves a little bandwidth. More importantly, it gives us the opportunity to focus on the attorney that's arguing, and it gives you the freedom to roll your eyes, throw down paper, shake your head, etc., without having to worry about offending the court, which that kind of behavior tends to do when in open court. Finally, because the judges don't have the opportunity to look left and right and sort of get a sense of the room about who's going to be asking a question and so forth, we just channel our inner elementary school children, and when we have a question, we raise our hand. Or at least we try to remember to do that. And if you could be mindful of that, you do not have to stop mid-syllable, mid-sentence, maybe mid-paragraph to take our question. As you know, very often the most important part of oral argument is getting the court's questions answered. But feel free to finish your thought and then take our questions. And other than that, oh, yes. We do record the proceedings as always. We sometimes have occasion to go back and listen to the argument. So when you first take the virtual podium, if you would state your appearance for the record, and in the case of do that both times you take the podium, we would appreciate it. Then if we do go back and listen to the arguments, we know who is saying what when. Any questions about any of that? Let me ask my colleagues if I seem to have left out any of the important reminders. Very good. Thank you. With those preliminaries out of the way, then, we will hear appellant's argument in Hinds versus Hinds-Holm.
All right. Good morning, Your Honors. Thank you. And, Your Honors, I think as I prepared my remarks today, and feel free, as I say, if you have any questions, by all means, interrupt me as soon as you'd like so I can address those. But in preparing my remarks for today, I think it's a fairly straightforward case from a legal perspective. What we are challenging is the sufficiency of the evidence, that we've got a burden of showing clearly erroneous mistakes here, and I think we can do it. And so this is a case factually where...
Talk about that, Mr. Weckel, since you started there. Is this really a factual challenge? Because you framed it in your brief in terms of your issue statement and your standards of review as if it is. But it strikes me, reading your briefing, that what you're really after is the ultimate decision to grant custody to father. And my understanding of the case law is that that question, that ultimate decision, is a discretionary decision with the district court that is done under the auspices of the abuse of discretion standard of review.
Oh,
so
I don't,
if you can help me with that.
Yeah.
Is this factual or is this discretionary, what it is that we're looking at?
Well, I don't think it's discretionary. It's obviously the judge has discretion to do whatever he wants. I'm not sure I understand your question.
Well, okay, let me ask the first part of it then. the thing that you want us to do is say custody should actually have gone to mother, not father,
Exactly.
right?
Yeah, yeah.
Okay, so the custody decision, is that discretionary or is that factual?
I'm not sure I understand the question. The judge has discretion to do what he wants to do, but if he misapplies the law, then that kind of an error is that there's not enough evidence to support that particular ruling. Okay, and so therefore it's a mistake. It's just clearly erroneous based upon the evidence that was presented.
Can I interrupt you there?
Yeah.
This is on the same line of thinking, because I too was the statement of the issues. The first sentence says whether the court correctly applied Utah authority in its child custody determination. That question, I think, whether a trial court correctly applies the law, could be one that's reviewed for correctness. For example, if the trial court applies the wrong law, or if they, for example, let's say a statute has a 3-element thing, and they say you got to consider these 3 things, and they're connected by the word and the trial court only considers the first 2. That is a purely legal question at the end of the day. Did the trial court skip element number 3? And that is typically reviewed for a correctness. And also, then the second sentence says the standard review for sufficiency of the evidence is challenged for clearly erroneous. And I'm not necessarily convinced that that's accurate either. Typically, that question is total sufficiency, whether the quantum of evidence demands a certain result at a certain level is a legal conclusion, again, to be reviewed for correctness. Now, on the other hand, as Judge Tenney is pointing out, if the question is whether the court made the right call, ultimately, given all the subsidiary facts being what they are, that would probably be reviewed for abuse of discretion. And so
okay.
Finally, you note that there are motions that have been made under Rule 59 and Rule 52. Rule 59 motions almost universally are reviewed for abuse of discretion, although I will grant you that if your claim is that the trial court missed it on the law, although that's reviewed for abuse of discretion, it has a pretty hefty legal question embedded in it. So that's a long way to get to this. What exactly do you claim, or how did the trial court get it wrong?
Well, I would, if you want to use a de novo review versus a sufficiency of the evidence review and abuse of discretion, certainly you can. I think that the judge.
Well, I can understand why you might want to glom onto that with all due dispatch. It's usually a good thing for an appellant to see a correctness standard, but that's an important distinction here, because if that is your claim, and I really want to know the answer to the question, if this is your claim, if you claim that given the factual predicate, as a matter of law, the trial court got this wrong, then that tells us that you are not challenging any of the factual findings. So in this case, is that accurate that you are not challenging any of the factual findings?
Couched in that particular way, Your Honor, I would say correct. We're challenging the application of the law.
So we can take the factual findings that the court made as the court made them, and then we basically look at the algebra, and the conclusion is it doesn't add up. The court did the wrong thing.
Yes, that's my primary argument. I think that there were some mistakes also in terms of the evidence as far as the findings that were prepared by opposing counsel. But the principal argument is that given the statutory factors for custody, stated in 30-3-10 and the Hudima versus Carpenter precedent, which has been cited much over the years, that the judge relied upon. He didn't do the math correctly. You're right. That's a good analogy. He didn't.
And what do you mean by that? He didn't do the math correctly.
Well, in other words, there's 15 or so factors. And what he did, Your Honor, is that he put the greatest emphasis on the fact that he thought the parties would not co-parent properly.
Okay, so when you say that the claimed error is that the judge put too much emphasis on one factor or another, that gets back to the question that I was leading with. That sounds to me like a purely discretionary call. I had always thought that the question of how to balance the factors is the part of this that is discretionary.
No,
am I wrong? Tell me why that's wrong.
It's wrong. Hudima versus Carpenter states very clearly that there are certain not all of the factors weigh the same. That's the state of the law in Utah. And the factors that are much more important are who was the primary caregiver, continuity of placement, where this is a little kid, okay? And if the kid's doing well, and bonding is also a factor, ties to the community, et cetera, all of them are important. But certain factors, and Hudima just says this quite starkly, is that these factors of who is the primary caregiver is really important to a little kid.
Okay, well, I'm looking at Allen versus Allen, which is a decision from our court, and it says, quote, in custody matters, appellate courts generally give the district court considerable discretion because the district court's proximity to the evidence places it in a better position than an appellate court to choose the best custody arrangement.
That's a general comment, Your Honor. I mean, that's true generally. I mean, you're not there. You're not going to be looking at the witnesses in terms of credibility, et cetera.
Right, but the last time, I'm sorry, you cut me off before I got to the key part.
Okay, go ahead.
The key part was it places it in a better position than an appellate court to choose the best custody arrangement. So what I hear you saying is you think that there are certain factors that should have caused the district court to choose a different custody arrangement. But that's the very thing. I'm sorry, I'm not done. That's the very thing that we have said repeatedly that is the district court's call. What's wrong with that?
Well, it overturns the Hudima case, basically, is what's wrong with it, because the Hudima case says, yeah, we got all these factors, but there's certain ones that are really important. And these are the ones that are really important. And it sets those forth, as I've said. And so when a court, I mean, yeah, they have certain amount of discretion, but if they pick some factor which is not in line with Hudima, I mean, like religious preference, I mean, that's the court has talked about that and said, even in Hudima, and said, well, that's not really that important. It is a factor, it's a statutory factor. But as an example, if a judge has said, well, I'm really placing a lot of emphasis on that, I mean, these people, whatever they're going to say about that, yeah, they have a certain amount of discretion, but they can't, if they want to override it, I haven't read the Allen case, but if you want to overturn Hudima, that would be a good way to do it, because Hudima identifies which factors are the most important and should be given great weight. Okay.
So are you saying that the law tells us which factors are more important than others, or does a trial judge decide that?
Well, I think that both the legislature and the Utah common law tells you what those factors are, where the statute is actually there's a conflict.
Oh, sure, but as to the relative importance of each, this is a quote from Hudima. Right. Generally, it is within the trial court's discretion to determine, based on the facts before it, and within the confines set by the appellate courts, where a particular factor falls within the spectrum of relative importance, and to accord each factor its appropriate weight.
Well, that's an opening line, Your Honor. But they go on after that to say, hey, yes, but, and then they state which factors are really important. Okay, and in this context, can
you quote me the portion of Hudima that says which factor must predominate over which other factor?
Yeah, I've got the second.
I may have missed it from your briefing, and if so, this would be helpful.
All right, let me just grab it here. All right, so in paragraph, let's see here, 26, says, although the court considers many factors, each is not on equal footing. Generally, it is within the trial court's discretion to determine, based on the facts before it and within the confines set by the appellate courts, where a particular factor falls within the spectrum of relative importance and to accord each factor appropriate weight. The importance of the myriad of factors used in determining a child's best interest ranges from the possibly relevant to the critically important. At the critically important end of the spectrum, when the child is thriving, happy, and well-adjusted, lies continuity of placement. In considering claims to custody between fit parents under the best interest of the child standard, considerable weight should be given to which parent has been the child's primary caregiver. Trial courts must examine a child's need for stability and therefore consider prior custody arrangements, including the duration of those arrangements and the potential harm to the child if the arrangement is changed. Existing arrangements in which the child is...
I'm sorry, can you account for the end of paragraph 27 then, which says that even where the continuity factor might go in one direction, there's still a discretionary component with the district court. I mean, the line is, consequently, as the court recognized, although the interest in stability still favored Hudema's retention of custody, it did not present such a high hurdle that, in light of the remaining factors, the court necessarily abused its discretion by modifying the custody order. So correct me if I'm wrong, so I might be. But that reads to me like what Hudema was saying was, yeah, in some circumstances, stability might be more important, but this is still ultimately a discretionary decision with the district court.
Well, of course. Yeah. No, of course, that's true. I mean, of course, the court always has...
So if that's of course true, then how did the district court here abuse its discretion by balancing the factors the way it did?
Well, because this is, in this particular case, what they said was the most important factor. It said this, the judge said this in his ruling after the Rule 59 hearing. And what he said was, yeah, I'm balancing all these things out, et cetera. Some, favor mom, some favor dad. However, the most important factor by and large is that I believe that mom was not cooperating in facilitating parent time. And that's why I'm putting the most emphasis on that particular factor. Well, that's fine, but there's also case law on that particular point. And that's the SIG line of cases where they say, if you're really causing a problem, in these cases, if you read them, I mean, you'll see that the parent was really causing a problem. That's when that factor comes into play as far as really putting a lot of weight on it. These are garden variety type of cases where people, I mean, the facts in this case, I mean, give me a break. I mean, I'm sorry, with all due respect here. Contempt claims are just so common in these kind of cases. And what was the upshot of these contempt cases? I mean, if you go back and look at the record, I mean, these contempt filings, we've got a $250 credit to dad for overpayment. And then there's nothing that happened. Okay, it'd be one thing if there was really egregious things going on. There wasn't any. Okay, okay, go ahead, Judge.
Let me ask you this, Mr. Weckel. I tend to agree, and over the many years that I've been reviewing custody determinations to gauge whether or not discretion has been abused, in my hierarchy of values, I've always sort of had the view, other things being equal, continuity, consistency is primary. Now, if there are some factors to go against that and the trial court explains those, well, fine. Sometimes continuity will have to give way to another important consideration. And I take your point that contempt orders come and go, and individual litigants might have problems keeping an attorney, etc. The point that caught my attention was Judge Blanche's specific finding that I think really transcends those more menial aspects of uncooperation, was the specific finding that, or series of findings, that father would do more to promote a good relationship with mother and son than the other way around. Quite the contrary. Mother has not done a good job and is not likely to do a good job. And I'm not obviously not quoting, but this seemed to be the gist of it. Mother cannot be trusted to do a good job in cultivating a good parental relationship between father and son. And I believe that father will do a much better job of cultivating a good parent-child relationship between mother and son. Now, that struck me as being the kind of thing that may well counteract the otherwise importance of continuity in a custody placement. And I apologize for the rambling nature of the background, but my question is, if I have it right, that Judge Blanche put a lot of weight on that fact, why would that not suggest we, when reviewing only for abuse of discretion, would have to go along with that judgment on his part? Do I have that right? First of all, is that was possibly his primary concern?
Yeah, that was his primary concern. I agree with you, but I don't think in line of the SIG case in the other case, I can't remember, I think it was Hansen, whatever, where these were egregious. I mean, there's case law out there addressing this particular point. And that case law, I mean, it's got to be pretty bad. I mean, and I would say even the math, balancing these things, that's fine if he wants to do that, but he's got to explain, okay, we got the primary caregiver here factor, which has got to be under Hedema, heavyweight. And we've got a little kid who's 4 years old. And we've got a great support system here in Utah where the child is in work-related daycare versus grandma, okay? And we've got all these other family members here for support, and we got nothing in Arizona, okay? And we got mom being proactive to attend to the child as far as taking him to a therapist, et cetera, and dad doesn't even know what's going on. We have all these other factors. It's fine. You have discretion generally. Yeah, that's true. You can say that. But you got to explain what's going on here. Why are you giving so much deference to this particular point?
Let me push back on that. If it were true, and I recognize that you're going to tell me it's not true, but if it were true that mom was not facilitating relationship with father, why couldn't that counterbalance what you're saying?
Well, because
That seems to be what Judge Blanche found. That seems to be the crux of his discretionary decision is he thought the facts showed that she was not going to facilitate time with father, and that therefore the only way to establish a relationship with both parents going forward is to give child to father. If that finding is true, then why isn't the end of the matter as far as discretion goes?
Well, because there's different reasons. Number one, the finding has to be true. And I don't know if it's true or not, but it's certainly, there's some evidence, marshaling the evidence that there is some basis for that.
Well, I thought you said to Judge Mortensen's question earlier that you weren't really challenging the factual determinations.
That's why I didn't want to get tricked. I'm sorry, with all due respect, judges, I didn't want to get tricked into saying something and not understanding exactly what you're talking about here. But I do think that the judge, I do believe that the judge misapplied Hedema. And I do think he misapplied the SIG line of cases associated with that particular factor. And so, if there's evidence to support that, okay, then yeah, the judge, that's fine. But what is the evidence? Okay. The evidence is that there were 3 contempt hearings. This is what's in the judge's ruling. There were 3 contempt. And what was the upshot? What were the squabbles over payment of, it wasn't, mom was driving. I mean, the evidence is she was driving to Monticello, Utah to have parent time. Okay. I mean, if that's not facilitating parent time, I don't know what is. And he doesn't show up. And the facts were he wasn't taking his parent time. He was not taking his holiday parent time for President's Day, for Martin Luther King Day, etc. I mean, you got to look at the record here. The record is that he was not cooperating also to facilitate the parent time. That's what the record shows. So you can, generally speaking, in theory, say anything. I mean, you can say, well, I don't find this, but you got to look at you got to have support factually to justify that particular conclusion. Okay. And that's what I'm saying is the record does not come to that conclusion. And we also have, and this is really important, in the Rule 59 ruling here, the motions here, he lets in part of a psychological record with the child without even, bringing the whole record in, double hearsay. And he doesn't put a lot of weight on the expert witness who didn't show up at the trial because of, whatever, these various problems, presents a 20-page report saying it's as if there has never been a custody evaluation done. This is the context of what we're talking about here. And he puts no weight on that, and he comes to the conclusion that he does based upon, I'm not speculating, this is what he says in his ruling, these contempt motions. And I might also add, Mr. Nguyen, with all due respect, was quoting things that the commissioner was saying, which is also hearsay. So I don't know how in the world, you find theoretically, yeah, you can do that. You have discretion, but you got to support it. You just can't pick something out of the hat and say, well, I think this, and ignore the record. Okay. And if you also have case law, which and you got facts which contradict your conclusion, well, I mean, you should be explaining, I didn't, I know Hidema, is a precedent here, and I know that she's been the primary caregiver for 34 out of the 49 months of the child's life, and I know that's really important. However, I'm saying that this overrides that. And by the way, I'm aware of the SIG line of cases which indicate that this has got to be really egregious stuff here, such emphasis on this factor. But I'm doing it because ABC. He doesn't do that. Okay, so that's...
I hate to cut you off. You are well over your time. In large part, that was due to our many questions and your answers to them. But I have the sense that the most recent question has now been answered.
Right. Okay.
And if you stop now, you can have your full 3 minutes on rebuttal. You're free to proceed making additional argument right now if you like, but that will come out of your 3 minutes.
No, I'll stop right now. Thank you.
Very good. We will hear then from appellee.
Thank you, Your Honors. Jonathan Nguyen, may it please the court, Jonathan Nguyen on behalf of the appellee, Bradley Hinds, the father. Let me first address the court's questions on the custody issue. We see this as a two-part issue, and each part has a different standard of review. So the first part would be whether the court abused its discretion by the way it weighted the different custody factors. If we look at Hudema, the court does in Hudema indicate that continuity should be something that's critically looked at and not disturbed unless it's a compelling circumstance. It's important first to note.
You agree then with the formulation that the sort of a discretion plus. So I don't know if that's quite the right phrasing, but within the discretionary confines, that gets treated differently. So you agree with that generally?
We agree that where the court weighs the factors is within the trial court's discretion. The second then issue would be the finding of the court. So the court made a finding in 161, finding of fact 161, that mother had severely interfered with father's relationship. So if the dispute is to that particular finding and whether there was sufficiency of evidence to support that finding, that would be under a different standard of review. And so the first standard of review, which is the abuse of discretion, Hudema specifically says it can be disturbed if there's compelling circumstances. And the line of cases that are cited by the appellant in pages 33, 37, and 38 of their brief specifically say when there is custodial interference, that is a compelling circumstance to upset the continuity. So SIG specifically and Hansen, both in those cases, specifically indicate that when there's interference by the parent, that then meets the qualifications as a compelling circumstance. That in and of itself results. The fact that we have a finding of fact by the court, 161, that says there is severe interference then we have met the burden that we need to for the abuse of discretion.
Mr. Weckel says in response to that there's just no evidence that she actively interfered. What's your best evidence to support that finding?
Okay, and that is the second part. So now we're switching now to the Nebaker case, which talks about the sufficiency of evidence of this court's findings. The court did find that there was severe interference. And throughout that trial and throughout the exhibits, there's substantial evidence. I'll point the court to one in particular, and that is the ruling of the commissioner. We would, at the same time, say that a ruling of a court is not hearsay. So the commissioner specifically ruled that there was interference. And to the extent of that interference, by the second time that the court came in front of the court on this interference, the commissioner specifically said, look, if this happens again,
Right. What was the evidence that she interfered? Mr. Weckel says there's just no evidence, and that the things that are being pointed to are so trivial. So what specifically did she do to interfere?
Chronologically, starting with the date of separation, she absconded with the child, left under false pretenses, kept the child from his father for 3 months. When an agreement was finally made for a parent-time visit, when father showed up to the visit, she wouldn't give the father the visit that had been agreed upon. Later, we made agreements for temporary orders, but because the fact that the temporary orders referenced school breaks, she told father he could not have any visitation until the child was old enough to go to school. Therefore, there would be no fall break, spring break, Christmas break. Kept the child away from there. And then the evidence went forth from every single visit, from the day of separation to the day of trial. There was roadblocks placed by mother for every single visit. The testimony was it was almost $20,000 of attorney's fees just trying to get his visits, because every single visitation was met with resistance by mother. There was times where he would show up to the visit not knowing if mother would even be there, waiting 30, 40 minutes to see if she'd even show up. Visits that did not occur. There were several instances where the court found that mother had tried to use visitation for leverage, and specifically instructed mother, you cannot use your visitation as leverage. So the under record has a slew of evidence, but I think it all accumulates to the point where the commissioner got so fed up with mother that she says, if this happens again, you're going to jail for 5 days. And that is something that does not happen on very many cases at all. So whether or not this reaches the line of holding of Sig v. Sig or Hans v. Hansen, both of those cases indicated that custody change, and again, in those circumstances, be it me, those were modification cases. Those were cases where a mother had already been awarded custody, and they were looking at, is there circumstances to modify that award of custody? This is an initial determination. So there is arguments even there that the standard is a little bit lessened when we're not talking about a modification case. But in this case, under Sig v. Sig and Hansen, they said that if there is evidence of interference, that justifies it. The word severe interference, that was added to by our court, Judge Blanche, where he said, in this case, I find that mother has severely interfered with the custody. Lastly, on the Nebaker
Mr.
case.
Wynn?
Yes, Your Honor.
Would it be part of your, and I don't want to put words in your mouth, but your explanation about the facts that support, is it finding 162?
161, Your Honor.
161. And your answer was responsive, but would it be your position, I gathered from the briefing, that line one of your defense would be take the finding as a given. There has not been a meaningful challenge to the adequacy of the evidence to support that finding by appellant. We don't have marshaling of the evidence. We have no explanation about what evidence supports that finding, and then an attack on the sufficiency of the evidence to support that finding. So isn't that your point one position? And number two, if for some reason we choose to look at it, there is indeed ample evidence to support the finding. And here again, I don't want to put words in your mouth, but that's what I took your position to be from the briefing.
Yes, you're correct, Your Honor, that if we took a look at two different standards of review, one is, was there an abuse of discretion given that this finding is correct? Then according to Sig v. Sig and also Hansen, if there's a finding of interference, then that supports the court's position in the continuity, disturbing the continuity. That's our primary position. The secondary position is, therefore, did appellant therefore disturb this finding? Did she meet her burden of proof in marshaling the evidence and finding? And that's where I was getting to with the Nebeker, is that standard is a high standard to show that it was insufficiently supported, the court's finding of interference. And that's what we've been referring to.
There is evidence that goes both ways. She had her own story. She had her own explanations, but he had his. And the trial court as fact finder can decide where the truth lies, basically. And it seems to have come down in making finding 161 in favor, essentially, of your client's evidence and testimony rather than the other side's.
That's correct. Both the trial court and the commissioner at some point said you can only make so many excuses until we no longer believe you. Now, pertaining to the second issue that was raised on the appeal, which is whether there was an abuse of discretion on the court's denial of the trial, continuance of trial request. When we look at the latent factors, there's 5 factors that's provided to the court as grounds to justify whether that was an abuse of discretion or not. The very first is we look at whether there had been previous continuances. In this case, it is undisputed that there had been 2 previous trial dates scheduled, and on both of those dates, just days prior to trial, mother asked to cancel those trials. So this would be the 3rd trial date. The court specifically found that there was extra delay in this case as mother moved from lawyer to lawyer. There was delays regarding to her inability to answer discovery and her failed cooperation in the custody battle. The second latent factor is whether it was an inconvenience in the parties. In this case, the pretrial disclosures listed 3 witnesses. All 3 witnesses were there and present. We had a custody evaluator who had traveled from Brigham City and taken the entire day off of work to be there to testify. We had father who had taken military leave of absence and traveled from New Mexico to be present, also the preparation he'd given. Even mother herself was present, taking time off work, and then arranged a sitter to be there. And as we pointed out in our briefing, we also should consider the convenience of the minor child, who almost a year previously, the court-appointed expert had indicated it was against the best wishes of the child to remain in that temporary order. There had been a continued delay of almost a year after that expert opinion had been entered. The next we look at is, was there a justifiable reason for the delay in requesting a delay? And in this case, mother's only reason given was to hire her 5th attorney. At the time that her 4th attorney was allowed to withdraw, the testimony presented to the court was that mother was ready to prepare for that trial and would be proceeding pro se, and that she was going to go forward. And Leighton, specifically in footnote 4, indicated that not having an attorney is not grounds for a motion to new trial unless there's a constitutional right to an attorney. The 4th factor is the contribution by both parties and who's contributing to the need for the delay of trial. And in this case, it was clearly mother by her unilaterally firing both her 3rd and her 4th attorneys and waiting to hire a 5th attorney until several days after the trial. So we're left with the last factor, which is the primary factor, whether or not there was prejudice by mother when the court did not grant her motion to continue the trial. The first thing that was raised by mother was that she was prejudiced by not having an attorney. However, the findings of fact by the trial court was that she actually was well prepared and presented herself well. She cross-examined witnesses and impeached the expert. Counsel indicates that had an attorney been present, she would have been prejudiced by hearsay comments, again referencing the ruling of the commissioner, that's the court. That ruling that was made on the court record was not a hearsay statement. Next, mother argues that she did not have proper timing, proper notice of the trial date. However, this is contrary to the evidence in the record. In this particular case, we have 2.5 years of notifications to mother. The first notification was the notice of events deadline, telling mom, you need to be ready by such and such a time. And then since that notice was given, there was 10 further notices. On top of that, the trial brief of the mother in page 46, she indicates that the first trial date, September of 2019, that she was prepared for. So she can't adequately argue that 6 months later she would not have been prepared for trial. The next issue mother raises under the prejudice is that by the court not continuing the trial, she was prejudiced by not having a rebuttal expert present. However, the court already addressed this issue on 2 different arguments. First, the trial court indicated that even if that expert had been available, the court would not have allowed that expert to testify. because she did not follow the proper civil procedure rules in designating that expert as a witness. At two separate occasions, she was given the opportunity to file a motion to reopen expert discovery and provide her proper disclosures, and she chose not to do so. Not only that, but when the agreement was made between the parties in the informal trial to allow a rebuttal expert, she canceled the informal trial, knowing that if she goes to a formal trial, that expert would not be allowed to testify. Second, the district court specifically said, even if this expert were to testify, and even if speculating that testimony somehow made me feel that the court-appointed expert was less credible, I still did my own independent analysis of these factors. And because of which, any error that may be there would be harmless, because I independently have found these factors to weigh in the father's favor. And so there would be no prejudice there. The last allegation that mother made was her allegation that she was somehow prejudiced by not receiving her attorney's file, purely leaving to the court the speculation of what possibly could have been in this file that would have changed the outcome of this case. However, that is not what the Nelson court required that was cited by mother. Nelson required that a court might advise a client of their opportunity to get a file. And this was clarified again by this court in Allred when it indicated that the trial courts are not required to give specific instructions to pro se candidates. Does the court have any questions on the second issue of the motion to continue? Lastly, Your Honors, we would request that where father was awarded attorney's fees below, that we would be entitled to attorney's fees from the appeal above. Thank you.
Thank you, Mr. Nguyen. We appreciate the argument. Mr. Weckel, you have your full 3 minutes for rebuttal if you want to join us back on screen.
Thank you, I will. All right, so I'd had a chance to look at finding 161, and it's so vague. I mean, what it says is there's a pattern of misbehavior, of violating court orders. And again, this is what I alluded to, these contempt things, which you need to look at, particularly what happened with those things. Very, very minor. And not cooperating with custody evaluation. Well, Dr. Hale, this is also part of the evidence, said, okay, well, look, the custody evaluator had all kinds of resources, including bringing that to the court's attention and trying to get, cooperation, et cetera. But the record indicates the testimony of, and again, it's credibility of Rachel, was that she was cooperating. She just, look, this custody evaluation, she's supposed to, there's so many violations of this thing. This is, you can't ignore Dr. Oh gosh, what's her name?
Dr. Hale.
Hale, I forgot. Okay, Dr. Hale. You can't ignore this. This is, you can do what you want to do in terms of discretion, but if there's evidence there, you got to address it if it's cogent. And we got here a report by the doctor, Dr. Hale, okay, that just trashes the custody evaluator's recommendations to the court. And the judge is saying, well, she didn't cooperate. And Dr. Hale addresses that point in her remarks. So I would encourage you to take a look at what she said about that. There's evidence to indicate that, there was never any viewing of the child interacting with the parents. I mean, this is like basic stuff that was supposed to be done. The judge is relying upon the custody evaluator, and then they're missing all of this material. So the record in this case is really important, Your Honor. But if that's what it is, I mean, my understanding of findings of fact, you can find facts, but you got to articulate with some precision what you're talking about, not just have these vague allegations. Even if it was a contempt action, you got to look at the specifics of that particular contempt action, Your Honor. In terms of attorney fees, there was an attorney fee award of $500. This woman represented herself because she didn't have any money, and now there's an asking for it. That applies in cases when there's no good faith basis. I mean, here we've got a real chance of winning the case. I don't think there's any basis for an attorney fee.
Do you have a case that says that there's an overlay of bad faith analysis on attorney's fees and domestic actions like this?
An overlay, I'm not sure I understood what you meant, John.
Let me rephrase it. I understood you to say that there were attorney's fees granted below, and they've asked for them on appeal, and you said there's no evidence of a bad faith in bringing the present appeal. Do you have a case that says that as an appellate court, we need to look at whether the appeal was brought in good faith or not?
I don't.
In deciding whether, okay.
I don't have a case on that, but I would think that common sense would indicate that if you have a basis to appeal, and of course, if you prevail, I don't know how in the world you could get attorney fees.
No,
even
clearly, if you prevail, then the attorney's fees would not obtain. But I think what they're saying is if we affirm, then they want their fees.
I understand what they said.
Okay.
All right. Thank you.
Thank you, Mr. Ruckel. Mr. Wynn, if you'll join us back on screen for our little final ceremonial comments, and no surprise, it is we're not prepared to rule. We will take the matter under advisement and let you have our decision in writing as soon as we're able to get that taken care of. We appreciate your spending your time with us this morning, and with that, we'll be in recess.
Thank you, Your Honor. Nice to